Hi, welcome back. This is part 2 of environmental law discussion, and the topic we are going to discuss is sustainable development. All developments, whether economic, social, or political, are the needs and wants of humanity. Whereas it may cause pollution to the environment, it may also extract the entire resources too. The most important development system world has seen is nothing but industrial revolution. Due to industrial revolution, many industries and factories have created or established. As a result, the environmental pollution may cost very much. At last, we reach to the contemporary world of polluted environment. The object of protecting environment becomes the need of the hour. For getting a pollution-free environment, the one and only solution is that all industries and factories are directed to be closed. If so, what will happen? It would result in a degradation and retardation of development of all in all perceptive. In this future, in this juncture, uh, it is worth it is worthwhile to note down that environment and industries are for men. Therefore, both should be protected. But by how? Sustainable development is the only one and only solution in this contradictory issue. That is, you cannot shut down the industries and development completely. That is necessary for humankind. Whereas environment is also necessary for humankind. So we should find a balance between both. And that balance is found in sustainable development. So what is sustainable development? Sustainable development is development that meets the needs of the present without compromising the ability of the future generation to meet their own needs. And it was put forth for the first time in Bredenland report. Now, basic objectives of sustainable development. The principles of sustainable development seeks to achieve the following three basic objectives. The first one, to maintain production of goods and service for development and efficiency. Second, conservation and management of natural resources, including preservation of biodiversity and maintenance of biological integrity. The third, maintenance and enhancement of the quality of life, adopting the principles of equitable distribution of wealth and material resources. So these are three objectives of sustainable development, or basic objectives of sustainable development. Now these objectives may respectively called as economic, environmental and social objectives of the principles of sustainable development. So, with respect to objectives, from the environmental point of view, the objective of principle of sustainable development centers around three issues. That is, with respect to environmental point of view in sustainable development. The first one, to maintain essential ecological processes. Second, to preserve genetic diversity. And the third, to secure sustainable utilization of species and ecosystem. There is a very important case law in this regard, that is Fellow Citizens Welfare Forum versus Union of India, AIR 1996. It is also known as T.N. Tannery's case. Here, in this case, Supreme Court held that the eradication of poverty by social equity and conservation of biodiversity are both integral to sustainable development. So, eradication of poverty by social equity and conservation of biodiversity are both integral to sustainable development, and that was held in Fellow Citizens Welfare Forum versus Union of India, also known as TN, that is Tamil Nadu Tannery's case. Now, scope or extent of sustainable development. The concept of sustainable development, as pointed out by the chairperson in the Bredenland report, popularly known as by the chairperson Mr. Bredenland in Bredenland report, is aimed at meeting the needs of the present without compromising the ability of future generations to meet their own needs. Sustainable development involves a multifaceted approach, that is economic, human, environmental, and technological. It is a process which seeks to bring improvement in the quality of human life along with conservation of ecological system. The former UN General Secretary Kofi Annan had identified 5 areas of applicability of the principles of sustainable development, and they are water, health, power and energy, agriculture, and biodiversity. Former PM of India, Srimati Indira Gandhi, had categorically stated in the address at Stockholm Conference of 1972 that water, air, land, soil, plants, trees, and living organisms must be preserved because they are valuable natural resources for the benefit of the future generations. Now, towards the salient principles of sustainable development. The following principles are necessarily followed in order to achieve the objectives of sustainable development. These principles are: 1. Intergenerational equity. 2. Use of conservation of natural resources. 3. Environmental protection. 4. The precautionary principles. And 5. The polluter pay principles. 6. Principles of liability to help and cooperate. Now 7. Poverty eradication. And 8. Principles of public trust. So these 8 are the salient principles of sustainable development. So the first one, intergenerational equity. The principle of intergenerational equity presupposes the right of each generation of human beings to benefit from cultural and natural resources of the past generation, as well as the obligation to preserve such heritage for future generation. That is, to preserve such heritage for future generation. The principal emphasis on conservation of biodiversity resources and of the renewable sources like forest, water, soil, etc. The second one is use and conservation of natural resources. This principle requires that Earth's natural resources shall be carefully used in such a way that they may be conserved and enhanced for future generations. The third one, environmental protection. The environmental protection is an integral part of sustainable development. Most of the nations have enacted environmental protection laws to ensure sustainable development within their territories. In India, we have the Environmental Protection Act of 1986, which is a central legislation. The ultimate object is to ensure sustainable development for protection of environment from being degraded or polluted. And then we have precautionary principle. Precautionary principle is one of the basic principles of sustainable development. According to this principle, any substance or entity causing a threat, entity or activity causing a threat to the environment should be prevented from adversely affecting the environment. Now, prevention is better than cure. If there are threats of serious and irreversible damage, then the authority should make sure to avoid the happening of such an event rather than curing it after it has happened. Now, if there are threats of serious and irreparable damage to the environment, the state should adopt measures to prevent environmental degradation. Now, in MC Mehta versus Union of India 1997. So that is the Taj Trapezium case. Now, in this case, the Supreme Court applied precautionary principle. The environmental pollution affecting the Taj Mahal was considered by Supreme Court and held that there should be restriction movement of visitors and vehicles within 500 meters zone around Taj Mahal. Now, MC Mehta versus Union of India 1992. So that is the carbide case, 1992. Now, by applying the precautionary principle, the Supreme Court prohibited the mining and construction activities near lakes to protect them from environmental degradation. Now, here it is referred as Ganga pollution case and not carbide case. So, in Ganga pollution case by MC Mehta, the Supreme Court held that the applying precautionary principle, the Supreme Court prohibited the mining and construction activities near lakes to protect them from environmental degradation. Now, the polluter pay principle. The polluter pay principle imposes dual liability on the person or industrialist who caused the environmental pollution. According to this principle, the polluter is not only liable to pay compensation to the victims of the environmental pollution, but also to reinstate or restore the environment to its original condition or position. It has been held to be a sound principle by the Supreme Court in Indian Council of Enviro Legal Action versus Union of India 1996. So this is a case law of high significance with respect to environmental law, that is Indian Council for Enviro Legal Action versus Union of India. Same is the case with RLEK versus state. Now the Indian Council for Enviro Legal Action versus Union of India 1996 is also popularly known as the H acid case, and here polluter pay principle was laid down. Now, Indian Council for Enviro Legal Action versus Union of India is also with respect to coastal protection case. Now, some examples of the important case laws here is Value Citizen Welfare Forum versus Union of India, the Taj Mahal, MC Mehta versus Union of India 1997, the Taj Mahal case. Then MC Mehta versus Kamal Nath, that is a 2000 case. In this case, the Supreme Court observed that polluter pay principle has been recognized as fundamental objective of government's environmental policy to prevent and control pollution. So in MC Mehta versus Kamal Nath, that is a 2000 case, here the Supreme Court observed that polluter pay principle has been recognized as fundamental objective of government's environmental policy to prevent and control pollution. And the next we have is principle of liability to help and cooperate. Environmental problem is not confined to an individual or a nation alone. Instead, it is a global problem affecting the entire humanity and therefore has to be tackled with mutual cooperation and assistance. Then the next we have is poverty education. Poverty is perhaps the worst contributing factor for polluting the environment and causing its degradation. Most of the developing countries are facing the problem of poverty, which is adversely affecting their environmental quality. Now, the next eighth principle is principle of public trust, or the doctrine of public trust. Under the doctrine of public trust, the state is the trustee of all natural resources which are by nature meant for public use and enjoyment. Public at large is the beneficiary of these natural resources like seashore, water, air, forest, ecosystem, etc. The state, as a trustee, is under a legal duty to protect the natural resources. These resources, mainly meant for public use, cannot be converted into private ownership. This doctrine is otherwise known as rule in MC Mehta versus Kamal Nath. So MC Mehta versus Kamal Nath is a 2000 case, and we already discussed it, that here the Supreme Court observed that polluter pay principle has been recognized as fundamental objective of government's environmental policy to prevent and control pollution. So this case, MC Mehta versus Kamal Nath 2000, AIR 2000, also laid down the doctrine of public trust. Now, MC Mehta versus Kamal Nath, the court held that the state is a public trust of certain resources like air, sea, water, and the forest, which are of public importance. Here, a state had committed a breach of public trust. Now, similar cases to this is Mono Lake case, then Intellectual Forum versus State of Andhra Pradesh, then Value Citizen Welfare Forum versus Union of India, that is Tamil Nadu Tanneries case. So, as a overall, with respect to sustainable development, in India, there has been environmental degradation due to our exploitation of resources, industrialization, urbanization, and population explosion. But India has always been taking all possible steps for protection and improvement of environment, and at the same time aiming at sustainable development. The judiciary has played a very important role in the environment protection too. And some of the kind of pollutions we need to discuss is radioactive pollution, thermal pollution, then we have food pollution, oil pollution, plastic pollution, etc. So next we are going to discuss about some types of pollution, or the main types of pollution. The first one is air pollution. Air pollution means the presence of pollutants in the atmosphere in such concentration that causes injury to human beings and plants. Air pollution is the name for anything that makes the air dirty. Thus, air pollution is anything that contaminates the air and makes it harmful to breathe for humans, animals, and birds. To sum up the definition of air pollution, we can say anything that contaminates the air, something that makes the air dangerous to breathe and potentially dependent on the context, can be called as air pollution. Now, sources of air pollution. The main sources carrying air pollutants are: 1. The combustion of fuels to produce energy for heating and power. Then the second one is transportation, mostly the vehicular traffic. Now the third one is industrial and commercial processes. Then the fourth one is incineration, that is burning of waste such as rubber, plastic products, etc. without combustion equipment. The pollutants that contribute major portion of global air pollution are carbon monoxides, nitrogen oxide, hydrocarbons, sulfur oxide, and other particulars. Now we also have agricultural activities. So these are the general sources of air pollution. Now, with respect to types of air pollution can be both indoor and outdoor. So indoor air pollution. Indoor air pollution is a pollution of air in enclosed spaces such as our homes, shops, schools, and other businesses. It can be caused by numerous things like smoke from a domestic fireplace or the emission of gases inside a factory. It can be controlled by using detectors to detect pollution within the home or business and then controlling emission. Then we have outdoor air pollution. Outdoor air pollution is a pollution of air outdoors. It is usually caused by the emission of polluting gases from the burning of fuels in industry, car exhaust, and air travel. It can be limited by the reducing the emission that we create in in our homes and business. Now, causes. Air mainly polluted by carbon dioxide, nitrogen oxide, sulfur dioxide, etc. The smoke, this can fill the air with particles of soot that make it physically dirty. And gases, the poisonous gases are particularly dangerous. So the effects of air pollution can be: 1. Damaging to respiratory health. 2. Make buildings grimy. Then third one, aggravate allergies. And the fourth one, cause diseases. And fifth one, reduce biodiversity. Now, what remedy do we have, or what is the solution we have? Air pollutions can be checked by increasing forest and protecting forest. Industry should be placed long distance from the residential areas. We should be careful and alert that our our surroundings on our houses, street, drains are cleaned. Now, smoke-free furnaces should be used. Electric engines should be used more and not steam or diesel engines. Lastly, air pollution can be better controlled by way of combined effort of government and by private efforts. In order to prevent air pollution, our Parliament has enacted Air Pollution Prevention and Control of Pollution Act in 1981. So that is commonly known as the Air Act in 1981. Now, MC Mehta versus Union of India, 1991. And in this case, a writ petition was filed in the Supreme Court against heavy vehicular traffic pollution in New Delhi. The court held that right to live in a pollution-free environment comes under the purview of Article 21 of Indian Constitution. So MC Mehta versus Union of India, 1991. So it was a writ petition based on the heavy traffic and the air pollution thus caused in New Delhi. And the Supreme Court held that right to live in a pollution-free environment comes under the purview of Article 21 of Indian Constitution. Now, other relevant cases that can be discussed under air pollution is Shriram Food and Fertilizers case, then Oleum gas leakage case, then Delhi Industries case, the Taj Mahal pollution case, etc. Water pollution. Water is an absolutely essential element in the life of all organisms. It covers nearly one third of the Earth's surface. Clean and pure water is the right of every man. Water pollution means contamination of water with physical, chemical, or biological properties of water due to discharge of industrial effluent or any other liquids, gases, solid substance into water which is harmful for the public health of commercial activities or in agriculture. Now, sources of water pollution. The main causes of water pollution is the discharge of solid or liquid waste products containing pollutants. They are first one, domestic and commercial waste, second, industrial waste, third, agricultural waste, now fourth, air pollution, now five, chemical substances, now six, thermal waste, now seventh, radioactive substances, and eighth, suspended matter, etc. Now, effects of water pollution. Water pollution causes deterioration effects on the environment, which includes public health and safety, plants and animal life, and land and property, etc. The extent of water pollution in India is very obvious since all the 14 major rivers are highly polluted. It is essential that more than 60% of the diseases in India are due to pollution of water. Now, prevention of water pollution. That is, first, proper sewage treatment. Two, prevent river water to get polluted. Now, third, treatment of water before discharge. Treatment of waste before discharge. Now, fourth, strict adherence to water laws. Now, fifth, treatment of drainage water. Now, sixth, treatment plants in industries. Now, seventh, keep the pond water clean and safe. Eighth, routine cleaning. Ninth, self-hygiene. 10th, sanitation. 11th, public awareness. So, various measures have been taken for prevention of water pollution in India. The Indian Parliament passed the Water Prevention and Control of Pollution Act 1974, that is popularly known as Water Act of 1974, as supplement to the Environmental Protection Act of 1986 relating to quality of water. The Union Ministry of Forest, Environment and Wildlife has developed action plans for prevention of pollution of the river Ganga and Yamuna. Despite above efforts, the massive problem of water pollution still remains unabated. With respect to this, we have Narmada Bachao Andolan versus Union of India 2000 and Atmalinga Reddy versus Union of India in 2008. Now, both these cases is related to right to have access to drinkage water as a part of the right to life and human right as enshrined in Article 21 of Indian Constitution. The next is about noise pollution. Noise literally means sound. It is an unwanted or considered as unpleasant sound. Now, noise pollution refers to the disturbing sound that may cause harm to the human and animal life. Now, the sources of noise pollution. The indoor sources of noise pollution are loudly played music, stereos, radio, television, grinding machines, etc. The outdoor sources of noise pollution, commonly referred to as environmental noise, comes from airplanes, machines, trains, vehicles, industries, etc. Now, the effects on human health. That is the effect of noise pollution on human health. It may affect the human health, that is mind, health, behavior, physical discomfort to hearing, headache, deafness, stress, and high blood pressure. Now, effect on animal health. Noise pollution can cause death, temporary and permanent disability, push the rare species to extinction, etc. in respect of animal health. Now, protection. Personal protection against noise can be achieved by covering our ears with a cap, turban, or even the spreading out of palms of our hand in excessive noise situation. And solutions. Noise-producing traffic vehicles should be prevented from plying on the roads. Crackers that create extremely disturbing sound should be discouraged. Standards for noise control measures should be set up for industry and community. The existing ordinance and acts against dangerous form of environmental pollution should be revised from time to time depending upon the changing nature of the sources. Noise Pollution Control Laws. In England, Noise Abatement Act of 1960 was passed. In America, there is Noise Pollution of Abatement Act 1970 for prevention of noise pollution. In India, there is no law exclusively dealing with the problem of noise pollution. However, the following provisions are provided. That is the first one, Article 39, subclause E, then Article 47, Article 48, capital A, and Article 51, subclause G of Indian Constitution. The second, Section 268 and 290 of IPC 1860, that is with public safety and nuisance. Now, Chapter 3rd of the Factories Act 1948. Then we have Motor Vehicles Act 1988 and rules framed thereunder. And the fifth one is Environmental Protection Act 1986, provides for certain provisions. Now the cases. Now, Bijayananda Patra versus District Magistrate Cuttack, that is 2000 case. The normal tolerance capacity of noise for a normal person is 50 decibels and noise level up to 65 decibels may be considered as a tolerate limit. So that was held in Bijayananda Patra versus District Magistrate Cuttack, that is in 2000. And next we have marine pollution. So marine pollution is presence of substances that contaminates the sea. Marine pollution refers to the contaminants or presence of pollutants in ocean and sea. Causes of marine pollution: sewage, oil spills, chemical runoff from industry, and plastics and other waste from human lives are major pollutants in the sea. Polluting gases such as CO2 or sulfur dioxide can also dissolve in the sea and pollute it. Now, effects of marine pollution. The acidification of the oceans and the destruction of marine habitat, thus in its turn leading to the death of marine organisms and extinction of several species. Some of the main effects of marine pollution is oxygen depletion, higher acidity, spoiling bird feathers, then blocking out the sunlight, dangers to human health. Now, marine pollution refers to the contamination or presence of pollutants in the ocean and seas. The word marine comes from the Latin word for sea, and it is related to similar words such as mariner. Now, sources or causes of marine pollution. That is, 1. Toxic chemicals in water. 2nd, oil spillages. 3rd, small particles. Now, 4th, sewage. 5th, the shipping industry. And the 6th, dissolved greenhouse gases. Now, the control measures or solutions for marine pollution. That is the first one, be careful with the chemicals. Now, second, don't flush or rinse away harmful particles or pesticides. Now, third, campaigns. Now, fourth, ensuring no debris is released into the ocean. So, these are the measures that can be taken to avoid marine pollution. And the next we have here is Rio Declaration on Environment and Development. The most revolutionary step in the present decade was Rio Summit of 1992. It was also known as Earth Summit, which took place in Rio de Janeiro from 3rd to 14th of June 1992. It was a new dimension on the issue of environment and development in the international negotiation. The main object of the summit was to find an equitable balance between the economic, social, and environmental need of present and future generations, and to lay foundation for a global partnership between developed and developing countries as well as governmental agencies and private organizations. The main features of the Rio Declaration is that 1. The declaration contains 27 principles. 2nd, human beings are entitled to healthy, productive life and harmony with nature. Now, 3rd, all states shall cooperate for eradicating poverty, for sustainable development, and to promote standard of living. The 4th one, states shall cooperate in a spirit of a global partnership to conserve, protect, and restore the health and intergeneration equity of Earth's ecosystem. Now, the 5th one, states shall enact effective environmental legislations and shall maintain environmental standards. The 6th, in order to protect the environment, The precautionary approach shall be widely applied by the states according to their capacities. Now, seventh, peace, development, and environmental protection are interdependent and invisible. Now, the eighth one, states shall immediately notify other states of any natural disaster or other emergencies that are likely to produce sudden harmful effects on the environment of those states. That is with Rio Declaration and the main features. Now, the Environmental Protection Act 1986. The act came into force on November 19, 1986, the birth anniversary of our late PM Indira Gandhi, who was a pioneer in the environmental protection issues in our country. So the act came into force in November 19, 1986, and this was also the birth anniversary of our late Prime Minister, that is Indira Gandhi. The burning problem of the present day is the environmental pollution. In pursuance of Stockholm Declaration of 1972, several legislations were passed for protection and improvement of the environment. According to N.D. Tiwari Committee's report, nearly 200 central and state legislations are passed in India. Prominent among them are 12, of which the present act is of great significance and importance, that is Environmental Protection Act of 1986. The act aims to implement the recommendations of the Stockholm Declaration on the protection and improvement of environment. The act contains 26 sections and divided into 4 chapters. It was enacted by the Parliament on 23rd May 1986 and came into force on November 19, 1986. And the act extends to the whole of India, including Jammu and Kashmir. Now, the object of the act. This act was enacted with the object of providing for the provisions and improvement of environment. The preamble of the act gives the object of the act as given below. The first one, to implement decisions taken at the United Nations Conference on the Human Environment held at Stockholm in June 1972. The second, to take appropriate steps for the protection and improvement of human environment. And the third, to prevent hazard to human beings, other living creatures, plants and property. Now, the definitions. Now, the section 2 subclause A defines environment. Environment includes water, air and land, and the other outer relationship which exists among and between water, air and land and human beings, other living creatures, plants, microorganisms and property. So, environment is defined in section 2 subclause A. Now, environmental pollution is defined in section 2 subclause B. Environmental pollutant means any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to environment. Now, environmental pollution is defined in section 2 subclause C. So, environmental pollutant is defined in section 2 subclause B and environmental pollution in section 2 subclause C. Now to the general powers of central government. Section 3 to section 6 under chapter 2 of the Environmental Protection Act 1986 confer the central government powers to take measures to protect and improve environment. Section 3 subclause 1 empowers the central government to take all such measures as it deems necessary or expedient for protecting and improving the quality of environment and preventing, controlling and abating environmental pollution. According to section 3 subclause 2 of the Act, the measures taken by the central government may include all or any one of the following. That is 1. To coordinate actions taken by the state government, officers and other authorities under the Environmental Protection Act or under the Environmental Protection Rules. Second, to plan and extend a nationwide program for the prevention, control and abatement of environmental pollution. Third, to lay down standards for the quality of environment. Fourth, to lay down standard for emission or discharge of environmental pollutants from various sources. And fifth, to restrict areas in which any industries or operations or processes shall be carried out. Now, sixth, to lay down procedures and safeguards for the prevention of prevention of accidents which may cause environmental pollution. Now, the seventh, to lay down procedure and safeguards for the handling of hazardous substances. Eighth, to examine manufacturing processes, material, and substances which are likely to cause environmental pollution. Ninth, to carry out and sponsor investigation and research relating to problems of environmental pollution. 10th, to inspect premises, plants, equipments, machinery, manufacturing or other processes, materials or substances, and to give direction to take steps for the prevention, control and abatement of environmental pollution. 11th, to establish or recognize environmental laboratories and institutes to carry out the functions entrusted to such environmental laboratories and institute under the Environmental Protection Act. 12th, to collect and disseminate information relating to the environmental pollution. Now, 13, to prepare manuals, codes or guides relating to the prevention, control and abatement of environmental pollution. And 14th, to do such other matters as the central government may deem necessary for the purpose of securing the effective implementation of Environmental Protection Act. Now, MC Mehta versus Union of India, AIR 1992. In this case, the Supreme Court directed all cinema halls to exhibit slides on environmental pollution free of cost, and radio and TV for transmission of such information in national and regional language. That is for the creation of the awareness for the need for environmental protection. Now, Section 3, Subclause 3 of the Act empowers the central government to constitute an authority or authorities to issue necessary directions to the polluters to take necessary steps. Section 4 empowers the central government to appoint officers with such designation, functions and powers. They are under the direct control of the central government or the authority constituted by the central government. Now, Section 5, the central government can confer power on the authority to issue such directions as to closure or regulation of any industry. Now, Section 6 empowers the central government to formulate the rules on all or any matters regarding to in Section 3, Subclause 2. So, provisions under the Environment Protection Act for prevention, control and abatement of environmental pollution. So, that is discussed in Chapter 3, that is Section 7 to Section 17 of Environmental Protection Act 1986. And it lays down the provisions relating to the prevention, control and abatement of environmental pollution. Section 7, according to Section 7, person carrying on hazardous process shall not discharge or emit or permit to be discharged or emitted any environmental pollutant in excess of the prescribed standard or quantity. Now, Section 8 insists upon the persons channeling hazardous substance to comply with procedural safeguards. So, Section 8 insists upon the persons channeling hazardous substance to comply with the procedural safeguards. Now, Section 9 says that where the discharge of any environmental pollutant is in excess of the prescribed standard takes place due to accident or other cause, the person in charge of the place is bound to prevent or mitigate the pollution as a consequence of such discharge and shall also forthwith A. intimate the matter to the concerned authorities, and B. be bound if called upon to render assistance to such authorities or agencies as may be provided or prescribed. Now, on the receipt of the information, the authorities or agencies shall easily as possible or as early as possible cause such remedial measure to be taken to prevent or mitigate the environmental pollution. Now, expenses, if any, incurred in this connection can be recovered from the person who caused the pollution. Now, that is discussed in section 9 and section 10, power of entry and inspection. The central government can empower any person to enter any industry at all reasonable times to inspect any place, plant, records, etc. Now, by section 11, the section 11 empowers the central government or the authorized officer to take or collect samples of air, water, soil, or other substance for the purpose of analysis. Now, section 12 makes provisions for the establishment of one or more environmental laboratories. Now, section 13 empowers the central government to appoint government analysts for analyzing the samples collected. Now, section 14, the report signed by the analyst may be used as documentary evidence. Now, section 15 is a penal provisions, that is 5 years of imprisonment or fine of 5,000 or both. That is if there is any default in the compliance with the provisions of the Act. So, section 15 is a penal provision. Now, section 18 to 26 is miscellaneous provisions. So, we discussed that section 7 to section 17 discuss about the remedies or provisions under the Environmental Protection Act for prevention, control and abatement of environmental pollution. And section 18 to section 26 deals with miscellaneous provisions. Now, power to make rules is discussed under section 25 of the Act, and it empowers the central government to make rules. The central government may by notification in the official gazette make rules for carrying out the purpose and object of the Act. Now, section 26. Finally, section 26, which is the last section of Environmental Protection Act 1986, says that the rule made under the Act shall be laid or placed before the House of Parliament for approval. Now, to conclude, or a summary of the Environmental Protection Act 1986, that is, section 3 subclause 3 discuss about authorities, section 4 about officials appointed, now section 5 about powers, section 6 about rules framed by the central government, section 7 to 17 deals with prevention, control and abatement of environmental pollution, and whereas section 15 is the penal provision. Section 15 is the penal provision. Now, section 7 discuss about hazardous substance. Section 8 discuss about the safeguards to be maintained while channeling hazardous substance. Now, section 9 discuss about hazard substance, what shall be done in case there is an accident and there is a spillage, and that the authorities should be notified, and if necessary that the person who caused the spillage shall give assistance, and the authorities can recover any cost incurred from the person who caused the spillage of the hazardous substance. So that is discussed in section 9. Now, section 10 is the inspectors can inspect the place at any reasonable time. Now, section 11 discuss about the collection of samples to the laboratories. Now, section 12 discuss about establishment of 2 or more laboratories. Now, section 13 discuss about appointment of government analyst. Now, section 14 discuss about analysis to use as documentary elements. Then section 15 discuss about the penal provisions, which is if there is any default with the compliance of the provisions of the Act, the person may be made liable to up to 5 years of imprisonment and a fine of 50,000 rupees, up to 50,000 rupees. Now, section 18 to 26 discuss about the miscellaneous provision, whereas section 25 discuss about the power to make rules for the central government, and section 26 is discussed that, which is the last section, discuss about laying or placing the rules made under the Act for the approval of the Parliament. So that is with Environmental Protection Act of 1986. So this is the end of part 2 of discussion on environmental law. Thank you for listening. Thank you. Please. So if you have any feedback, please drop a comment. Now like, comment and subscribe. Don't forget to click that bell icon so that you get a notification when I upload my next video or a podcast. The first part is already uploaded. Please do listen to it. And we have one more part that will be uploaded soon.